In this chapter, we are going to discuss defense as we discussed prosecution last week. So the defense counsel has various functions, and we're going to go over these in detail. But to give you a quick introduction, a defense attorney has to faithfully represent their client, attack the prosecutor's case, counsel with defendants, and then negotiate with prosecutors in plea agreements. So, of course, just like prosecuting attorneys, defense attorneys also have to abide by a code of ethics, or what the ABA, and that stands for American Bar Association canons, guidelines, and rules for their behavior. So the first one is that they should assist in maintaining the integrity and competence of the legal profession. It kind of works the same way with police officers. You know, if one police officer does something that's wrong, then the whole profession gets blamed. And it's the same way with attorneys. That's why they have a reputation of being snakes in the grass, or I've heard them referred to different derogatory names, that you can't trust any of them. And that's because there have been some unethical attorneys out there. They also have to assist the legal profession in fulfilling its duty to make legal counsel available, assist in preventing the unauthorized practice of law, meaning not hiring people who are not qualified to be an attorney. They have to preserve the confidences and secrets of a client, and we will get into that in detail later. And they should also exercise independent professional judgment on behalf of a client. Now, besides all of these rules, all states have state bar associations. So these associations have considerable power over lawyers, because any person who wants to practice law in a state first has to be approved by the state bar in advance. So they go to law school, they graduate with their law degree, and then they still have to pass that state exam in order to qualify as a practicing attorney in that state. For example, I had a family member recently who is an attorney in California, and she moved back to the East Coast, and she lives in Virginia now. In order for her to continue practicing law in her new state, she had to sit for the Virginia State Bar exam and pass it. So just because you're qualified in one state does not mean that you're qualified in the next state. So the reason that we have defense attorneys, obviously, is that the Sixth Amendment guarantees each defendant the right to, one, is a speedy trial by an impartial jury. They have the right to be informed of the nature of the charges against them. They have the right to confront their accusers in court, and they have the right to have assistance of counsel for their defense. So the Supreme Court has interpreted this to mean that the right to counsel clause mandates provision of counsel to those who cannot afford it. This wasn't guaranteed to all states until 1963. So prior to that time, indigent, which means poor, indigent defendants were often prosecuted, tried, and convicted without an attorney simply because they couldn't afford one. So if a defendant chooses to, they can decide to self-represent themselves. They don't have to be trained or even be skilled in law, but usually a judge will still assign an attorney to assist them or advise them through the legal proceedings. But there's an old saying that says any person who represents themselves in court will have a fool for a client. Not too many people are successful when they represent themselves in court. I'm going to have two examples here. The picture on the left-hand side is Zacharias Moussaoui, who is a self-proclaimed Al-Qaeda member. He represented himself in charges related to the September 11th, 2001 attacks on New York City. His defense did not work. He was not a good attorney for himself, and he was sentenced to 6 life sentences. Then over on the right-hand side is a case that is a lot more recent, and we're going to discuss this several times throughout this chapter, is Dylan Roof. Many of you might remember that he was accused of murdering 9 churchgoers in a Charleston church. He was convicted in state court, and then he was also convicted in federal court for a hate crime. He's the first one to be successfully prosecuted for that, and he's on death row in a federal prison in Indiana. He decided that he wanted to represent himself also. So the attorney-client privilege. Obviously, it's intended to protect clients from having their attorneys disclose incriminating details of their lives to others, such as the prosecution. If a defendant confesses to the attorney, that attorney can't disclose that to the prosecution. So you can imagine the moral conflict that some attorneys may have with that. However, it doesn't extend to communication from the defendant of a possible crime that will occur in the very near future that will cause serious harm or death to someone. So a defendant can't say, hey, tomorrow I'm going to go kill someone, and you can't tell anyone because of attorney-client privilege. It doesn't work that way, thankfully. All right, so then the right to a trial by jury. So the Supreme Court, there's been some differences in how this has been interpreted, but ultimately the Supreme Court has ruled that a jury trial has to be granted to any defendant where the possible punishment involves incarceration of more than 6 months. And this case went to the Supreme Court back in 1968 and will be part of your homework assignment, where you will research Duncan versus Louisiana. And then lastly, we have the provision of counsel. So since defendants are obviously entitled to an attorney afforded to them by the Sixth Amendment, many states have set up their own legal aid services. A public defender system is the most common. We are going to cover the types of attorneys in the next PowerPoint, but for now you have understood a basic of the qualifications to be an attorney, and then the guidelines that they have to follow, as well as people who want to represent themselves.